In the family law context, the court assumes that the parents know what is best for their children. If the parents agree on how to share their children, generally the courts will approve it. What kinds of custody are available? You can look this up in Family Code Section 3000 and several code sections following that one. You will find that these code sections do not give either parent special privileges based on whether that parent is the mother or the father. They are gender neutral. Joint custody means that both parents have joint physical and joint legal custody. Legal custody means who gets to make the decisions relating to the child's health, education, and welfare. If you have joint legal custody, that means both parents need to make these decisions together. If you have sole legal custody, that means that only one parent can make those decisions. Physical custody means who the child lives with. If you have joint physical custody, that means that each of you have a lot of time with your child, according to a parenting plan or agreement or court order. Sometimes the court will order joint physical custody with primary residence with one parent. Sometimes the court order will order sole physical custody with one parent and a visitation schedule for the other parent. A parenting plan often looks like a visitation schedule. Parenting plans can be as unique as you and your children are, according to your children's needs and your needs. Agreements for joint custody can run the gamut from the children living with one parent and seeing the other parent only when available, to a true equal sharing, where the children spend one half of the time with one parent and the other half of the time with the other parent. Some families have a free flow between their two homes, but this works only when both parents are able to frequently and effectively talk with each other, and they live near each other. This is rare, and these people usually do not go to court because they solve their disagreements between themselves by talking it out and figuring out what is best for their kids by themselves. What happens when you, as parents, do not agree? You have several options. If you and the other parent are still able to have a civil conversation, try to find someone you both trust to help you work out what is best for your kids. This person might be your minister, priest, rabbi, or other clergy person. Or you could go see a therapist who specializes in helping families and children. If you can solve these problems this way, you and your children will be a lot better off. If none of these options work for you, you may be stuck going to court. This should be a last resort, but it is available if nothing else works. There are two public policies that guide decisions related to court orders for custody and visitation. The first one is the best interest of the child, and the second one is frequent and continued contact with both parents. Sometimes these two policies do not fit well together because of the circumstances related to either the children or the parents. When that happens, the best interest of the children is more important. The factors that the court looks at in determining the best interest of the children are listed in Family Code Section 3011 and include the health, safety, and welfare of the child, any history of abuse by any person seeking custody. If you and your child's other parent just cannot agree, how do you go about getting a court order? The process starts when one of you files an order to show cause to establish custody and visitation. You can watch the segment on orders to show cause to find out how to do the paperwork. This segment is to inform you about all the other things that happen when you do file that paperwork. First of all, before you can have a court hearing on your custody visitation request, it is required that you attend a family court service mediation session. Every county in California has its own family court services, and each county manages these services slightly differently from the other counties. So it would be smart for you to go to the family court services in your county and find out what their procedures are. Generally, you will have an appointment scheduled before your court hearing. Usually that is several days before, but sometimes it gets scheduled the same day. When it is scheduled the same day, Most often, the judge will put your file aside until after your mediation and will then see you later that day to finish what needs to be done in court. Some counties require that parents attend an orientation before they go to mediation. The orientation is a class, sometimes it's only a video, where you learn the procedures that are followed in your county, and usually some information on child development and what makes good parenting plans, and even maybe other local resources that you might be able to use for more help. In your Family Court Services mediation, you and your child's other parent will meet with the person who is a therapist, psychologist, licensed clinical social worker, or other professional who has had special training in mediation of custody problems. Each parent will have some time to tell the mediator what he or she thinks is going on and what should be done. The mediator will listen to both of you and try to get each of you to see where there are already some agreements and may suggest some solutions where you cannot agree. The mediator's goal is to try to help you figure out solutions where you disagree. When your session is finished, usually the mediator will write up a report that outlines those areas where you agree, and both of you will be asked to sign it. To prepare for mediation, make a list to bring with you outlining what you think the problems are and what you think the best solutions would be. If there are domestic violence issues or drug abuse issues or other issues that you believe will seriously affect the health, safety, or welfare of your children, be sure to tell the mediator. If there is no agreement or only partial agreement on some of the issues, then the mediator reports that to the court. There are two kinds of reports that can be made to the court, depending on which county your court is in. If you are in a recommending county, then the mediator's report will indicate what the disagreements are about and recommend a solution, such as a temporary arrangement and further mediation or a custodial evaluation. If your court is a non-recommending county, the mediator's report will probably indicate what you agreed on, but not say anything else about what you did not agree on. After mediation, in your quick court hearing, the judge will make some orders. If you came to agreement in mediation, the judge will usually turn your agreement into a court order, but he or she might ask you some questions and change the agreement a little bit based on his or her knowledge of your case. If you did not come to an agreement in mediation, the judge will usually make some temporary orders for a parenting plan to hold you until a custodial evaluation can be done. These temporary orders will be based on the mediator's report, your case file, and what is learned in the hearing. If you have a case that is ordered to evaluation, you need to get prepared. It will cost you a lot of money, usually more than $1,000. It will take a lot of time, usually 2 or 3 months. The evaluator is a specially trained psychologist or other mental health professional. You will have many meetings, some by yourself, some with the other parent, some with your children. You will probably have a home visit. The evaluator will probably talk to the children's teachers, pediatrician, daycare provider, and other adults who know your children. You may be required to participate in a psychological evaluation, which includes psychological testing. After all this investigation is done, the evaluator writes up a long report which talks about you and your child's other parent, your children, your family situation, what is good, what is not so good, and based on that investigation and the evaluator's knowledge of child development and human psychology, will make a recommendation for a parenting plan. You will be allowed to read this report, but most courts do not allow the parents to keep a copy of the report because it might be harmfully used in the future. However, some courts allow the parents or their attorneys to submit their comments about the report shortly after having the opportunity to read the report. Send the comments in a letter addressed to the judge and send a copy to the other parent. The judge will read the report and the written comments. After the report is sent to the court, the judge will hold either a settlement conference or a hearing, or both, to come to a definite parenting plan, which will become a court order. If your case includes domestic violence, you may need some special help. You can contact your local domestic violence agency for additional help or referral to other resources. Also, way back at the beginning of this segment when I talked about mediation, it is important for you to tell the mediator about the domestic violence so that a parenting plan can be figured out that is safe for you and your children. It is possible that the court will order you, your child's other parent, or both of you to attend anger management counseling or a parenting skills program to teach you other ways of handling yourselves when things don't go the way you think they should. If your case includes substance abuse, that also must be brought out in mediation and in court. When you bring the subject up, because it is a very sensitive subject, you will be asked why you believe the other parent is using drugs and what drugs are being used. If there are DUIs, driving under the influence, or other drug-related arrests, tell about them and when they happened. Provide documents if you have them. If there are no arrests but there are recent incidents, describe them. Describe the drug-induced behavior and how often it occurs and when you last saw it. If you have your own history of substance abuse, talk to an attorney about admitting it and detailing what you've been doing to change yourself. If your evidence sounds believable to the mediator or to the judge, it is possible that the court will order one or both of you to submit to a substance abuse test or assessment. If you or your child's other parent has a personality disorder or mental illness, that must also be brought to the court's attention through mediation and the court hearing. Like substance abuse, you will be asked for the basis of your claim. If there has ever been a diagnosis, tell the court about it. If there is any documentation, provide a copy of it to the court. If neither of these exists, then simply describe the person's erratic, strange, and dangerous behavior as well as you can. It is possible that the court will order a psychological assessment to find out if the person is safe to be around the children. A lot of times this issue comes up when you are in the middle of the custodial evaluation described earlier. If the court finds that one of the parents may be dangerous to the children, then the court usually orders supervised visitation to ensure that the child will be safe. For more information on visitation, watch the segment on visitation and parenting plans. If you have a high conflict case, meaning you and your child's other parent can never agree on anything and you fight about everything, you may be in for a very unhappy and long process. Even worse, you may be hurting your children. Recent research indicates that one of the worst things you can do to your child is to fight over him or her, unless it is a matter of your child's health, safety, or welfare. You should concentrate on what's going on in your own home and make it the best and most accepting place you can for your children. It is important that you never say anything bad about your child's other parent, because if your child hears you or even learns that you are saying those things, your child may believe that you think that about him or her, because your child is one half of the other parent. Don't let your friends or relatives badmouth your child's other parent or other parents' friends and relatives either. The best things you can do for your child are to heal yourself from the hurts of your former relationship. Make a good life for you and the kids. Stop fighting over the kids and share them willingly and freely. The next best thing you can do for your child is to get educated in child development and parenting issues. Go to your local adult high school or junior college. Look under child in the yellow pages to find agencies who offer these classes. Go to the bookstore and find some books that will help you understand what is happening from your child's point of view and offer some good tips for effective parenting. Also, you might find a counselor for you and your child's other parent to help you co-parent. That is, if you don't have a high conflict case or one with substance abuse, domestic violence, or mental illness. Kids are pretty resilient and usually thrive if their basic needs are met and they know they are loved. When you have to make a decision about your life and your family, always ask yourself, how will this affect my kids? If it will make their life better, go for it. In your family law court case, always keep your eyes on the prize. That is, what's best for my kids.